66 with respect to the applications of both Skipjack Offshore Energy, LLC, and U.S. Wind Incorporated. Before we get started this morning, just two items quickly. Last evening, we handled off the record an agreement to stipulate the testimony of the business network for offshore wind. We will now admit that testimony of Elizabeth Burdock into the record. I've marked it as Exhibit BNOSW number 1, and that piece of testimony will be moved into evidence. Additionally, yesterday we got relatively lucky. We only had to go into confidential session on one occasion. What we will do is if we have a witness and we find ourselves having to go into a confidential session, I would ask that any attorneys seeking to cross-examine that witness examine that witness with any non-public materials at that time. That would require that we only go into confidential session once per witness. I recognize that this may throw off some of the order of questioning for counsel, but that is what we'll do to be most transparent with the public. Additionally, any attorneys that seek to cross-examine a witness, please have your camera on for the duration of that witness's testimony. I see a question from counsel for U.S. Wind. Good morning.
I'm sorry. Good morning, Your Honor. Good morning, Commissioners. Mr. Priebus for U.S. Wind. After Your Honor made the point about the necessity of the public to hear sort of the bids and the impacts of each bid, we went back to our client and asked if it would be comfortable declassifying at this stage of the proceedings its bid and ratepayer analysis for the purpose of streamlining proceedings and also for the purpose of allowing the public to better understand what the bids are and the ratepayer impact, considering that we're now at that stage in the proceeding. We'd be prepared to do that. I will say that Skipjack has classified its materials, the same kind of materials, also as attorney's eyes only, and that would, if they are still going to continue with that classification, much of my examination of Mr. Kane today, if not all of it, will have to be in the sphere of confidential attorney's eyes only and without the public. But we would be willing to have Mr. Rupture be fully public, and would ask Skipjack if it's appropriate to do the same with Mr. Kane.
So that I'm clear, U.S. Wind is willing to declassify all of its non-public documents at this time?
No, Your Honor. The non-public document with specifically respect to the bid and all the ratepayer tests and analysis with respect to the bid.
Okay, all right. So the financial
direct pricing and bid and ratepayer analysis.
I understand. Okay, so limiting to OREC pricing and ratepayer analysis. Mr. Coran, would you like to respond?
That's the first we've heard of that, Your Honor. If that's something I'd have to consult with my client about, certainly we'll do that. As for Mr. Kane's testimony, not sure the issues that Mr. Priebus is raising regarding U.S. Wind's or Skipjack's OREC price bids would restrict going to public session with Mr. Kane's testimony, because the vast majority of it is public. And in fact, I think very little of his testimony is confidential. So we'll have to discuss the one issue with our client, Your Honor. But as for Mr. Kane and his testimony, the vast majority of that is public testimony.
Okay. It is reasonable for you to have an opportunity to speak with your client, although I anticipate this is the last day of sponsoring of any Skipjack witnesses, so that might be a moot point by 5 o'clock today. We will accept U.S. Wind's offer to make public that information with respect to OREC pricing and ratepayer analysis. And if we have to go into closed session with respect to Skipjack witnesses, we will.
Thank you.
Any additional matters we need to discuss before we get going this morning? Mr. Fields.
Yes, thank you, Your Honor. William Fields for the Office of People's Counsel. I think it's a great idea to make more information public. 2 points on that. One, Mr. Previs talked about ratepayer impact analysis, and part of the confidentiality issue with that is forecast and analysis by consulting companies that both U.S. Wind and Skipjack hired as part of that process. And I guess it's still a little unclear to me exactly what's going to be public now and what's going to be confidential. Related suggestion or request would be for the companies that decide to make more information public to file new versions of the documents. The documents that we have now are all marked with this confidential. If they could file new public versions of their testimony that they're declassifying, that would be extremely helpful, both for those of us working on the case and then also for the commission's record, for the future to have a document that actually says that it's confidential on it. If it is going to be, have a document that says public when the intent is for the information to be public. Thank you.
Thank you, Mr. Fields. That is not a bad idea, although I recognize that's an additional burden on both party that wishes to declassify. I'll give Mr. Previs an opportunity to think about this and respond tomorrow, whether they're able to do so or whether we sort of take him at his word with respect to what we deem now in the public space. Mr. Spivak.
Good morning, Mr. Chairman, Commissioners. I just wanted to second Mr. Fields' last request. It would very greatly simplify being able to use the testimony if that's designated public, if we could get a version of it that were actually marked that way. Otherwise, it gets very confusing, especially if that's going to be the case for multiple pieces of testimony.
Thank you, Mr. Spivak. We'll hear from Mr. Previs tomorrow regarding this. I don't know if the testimony needs to be refiled entirely, or perhaps just a letter stating which pieces are now open per witness testimony and available for the public. So sort of an amendment or a cheat sheet might be easier for the company, but we'll hear this tomorrow morning. Anything else?
May I ask just a follow-up, Your Honor?
Yes.
In the course of Mr. Kane's testimony today, if Mr. There's a point in which I think I understand where it may switch over, and if Mr. Curran could just please provide us guidance at that time as to whether I can kind of signal where I'm going, and then maybe we could deal with it at that time.
Okay, and then we'll let Mr. Curran jump in at that time, signal that we need to move into closed session. Additionally, any other counsel that wish to cross Mr. Kane should have their non-public cross ready, even though it might be out of order. Mr. Curran, anything else from you?
Nope, we'll do our best there, Your Honor. Nothing else.
Okay, thank you. I was happy that we were able to move with relative ease through the testimony yesterday. Let's hope we could do that again today. Mr. Curran, if you could please call your next witness.
Yes, Your Honor. Thank you. We would call to the commission Mr. Paul Hibbard.
Mr. Hibbard, Chairman Hibbard, if you could please turn on your camera and raise your right hand.
Mr. Chairman, good morning. I see that my camera's on. Are you not seeing it?
There was a delay. We see you now. Thank you. Madam Court Reporter, you may be on mute. You want to lower your hand for a moment? We'll see what's going on.
Okay, I think I'm off mute now. Can you hear
Thank you,
me?
Linda.
Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter pending is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You're a witness.
Yes, Mr. Hibbert, would you please state your full name for the record?
Paul Hibbard,
And what is your business address, sir?
111 Huntington Ave, Boston, Mass.
And can you tell the commission who your employer is and what your title is?
My employer is Analysis Group, Inc., and my title is principal.
Thank you. And who are you testifying on behalf today, sir?
On behalf of Skipjack.
Thank you. Mr. Hibbert, do you have before you two documents that have been entitled respectively, the public and confidential rebuttal testimonies of Paul Hibbert dated October 18th, 2021, consisting of 29 pages and one exhibit?
I have that, yes.
Your Honor, we'd like to have the public and confidential versions of Mr. Hibbert's rebuttal testimony that were pre-marked as Skipjack Exhibits 9 and 9C to be marked as Skipjack Exhibits 9 and 9C respectively.
So marked?
Mr. Hibbert, was this testimony prepared by you or under your supervision?
Yes.
And sir, today, do you have any corrections or additions or deletions or clarifications to your testimony?
I do not.
So if I were to ask you the same questions that are contained in your rebuttal testimony, would your answers be the same?
Yes.
And is your testimony true and correct to the best of your information, knowledge, and belief?
Yes, it is.
Thank you. Your Honor, at this time, we would respectfully move that Skipjack's Exhibits 9 and 9C be moved into evidence.
Seeing no objection, Skipjack Exhibits 9 and 9C are accepted into evidence.
Thank you, Mr. Chairman. At this time, the witness is available for any cross-examination.
Thank you. Mr. Priebus.
Thank you, Your Honor, and good morning, Mr. Hibbert. Tom Priebus, half of U.S. Wind. Just a few questions for you. When was it that Skipjack retained your services in this case?
I don't remember the exact date. It would have been sometime in September.
Was it after the ICF comparison report had been issued?
I believe so, yes.
So when you were retained, you were aware at that time that Mr. Kane's ratepayer analysis had received a 1 or high level discussion of methodology and results, but concerns with the approach from ICF, and that his energy markets analysis had received a 0 or little to no discussion of methodology or methodology applied below reasonable standard. Were you aware of that opinion at the time you were retained?
Upon retention, I reviewed the ICF report.
And that's what it said, correct?
I'll take your characterization. I don't know the exact words.
And you were hired to rehabilitate that opinion of Mr. Kane against the ICF report, correct? To rebut, excuse me, I'll rephrase that question. You were hired to rebut the ICF report in support of Mr. Kane's opinion, correct?
I was hired to evaluate the positions taken by ICF and Mr. Rupture and Mr. Chang with respect to the modeling platform issue.
Do you consider Mr. Chang an expert in the field of energy markets?
I don't have an opinion on Mr. Chang.
Do you consider PA Consulting or Mr. Rupture an expert in the field of energy markets?
I have formed that opinion. I'm aware that they have been, that all of the witnesses here have been active in energy markets and energy policy for a fairly long time.
So you would also say that Maria Scheller of ICF is active in energy markets and an expert in energy markets, and that ICF's been doing it for a long time as well. Is that correct?
I do not know her personally. I have been aware that ICF has been producing analyses for a long time.
And isn't it true that each of these experts criticized the energy forecasts of Mr. Kane, and it was each of their opinions that it was below a reasonable standard for use by energy market professionals, excuse me, isn't that the case?
I probably wouldn't say it exactly like that. I am aware that all three of them suggested that the use of econometrics with production cost modeling was not industry standard, and that's the issue that I took issue with.
And your testimony, and I think you said it at page 6, line 17, and page 18, line 8, that their opinions about Mr. Kane were quote unquote absurd on their face. Do you recall that testimony?
I do.
And that's, I'm sorry.
To be clear, I apologize. To be clear, what I am saying is absurd on its face is the idea that econometrics is not industry standard modeling.
But their opinions were looking more than just whether econometrics or industry standard modeling. They were also looking at the very specific methods and use of that modeling by Mr. Kane in this case, as applied in Maryland in the ratepayer analysis, correct?
Yes, I believe their opinions went beyond that.
Okay, I think at this point I understand, and I'm just going to reserve the remainder of my questions about ratepayer analysis to Mr. Kane. So thank you, Mr. Hibbert. Thank you for coming in. Thank you for your testimony.
Thank you.
Do commissioners have questions for witness Hibbert? Mr. Herman.
Thank you, Mr. Chairman. Good morning, Mr. Hibbert, or would you prefer I call you Chairman?
Mr. Hibbert is fine. Good morning, Commissioner.
Okay. Well, good morning, and thank you for your testimony. So in a couple of places in your testimony, on pages 7 through 8, and then on page 21, you talk about how inputs and assumptions are critical in developing a good forecast. Is that right?
Yes, absolutely.
Okay. So on page 8 of your testimony, just at the very top of the page, you say that these assumptions are important and difficult to anticipate, given the changing nature and structure of supply and demand. Wouldn't that be a good reason to be more conservative than less conservative in your inputs and assumptions?
Commissioner, I'm not quite sure what you mean by conservative. I assume that you mean, tend to make assumptions that are likely to reflect one person's opinion about what represents being conservative or not. When I view this, the testimony that I'm giving in response to this answer is really a focus on how the industry is changing in ways that are far removed from what we're used to and what we all have been used to in the industry over the past couple of decades. So I actually, the point I'm making is really just that the modeling process has become more complicated when on a forecast basis. And that makes it really important to think about how do the assumptions that are going into the models look when considered through the lens of the decarbonization policies that are being administered by states going forward.
Right. Well, I guess, what I'm getting at is that, of course, Mr. Kane's analysis is, I've been using the term more aggressive than that used by ICF and the U.S. Wind witnesses, and those forecasts, again, my word, more aggressive forecasts impact the ratepayer impact of these bids. And that's where it's really important to us. And so wouldn't it, as the former head of the Massachusetts Commission, wouldn't you potentially be inclined to be, maybe a little more conservative than you might otherwise be?
I would, Commissioner, with the caveat that I think that when you look at the way the industry is changing, what conservative means may be very different than it does when you're looking historically. And, in particular, the thing that I think is so important in modeling now of ratepayer impacts is consideration of how electrification of the building and transportation sectors will affect the electric sector. And, it's sort of obvious that on a going forward basis as electrification takes hold, the impact on the electric sector will be significant. So I wouldn't want to look at a modeling exercise and just accept a load forecast or a fuel price forecast that kind of looks like the way we've been doing it for the past 20 years, because the world going forward is so much different. So I'm having a hard time putting your comment about aggressiveness or conservatism within that context. I think my testimony to the commission is that this is a rapidly changing world, and it's really important to understand what these assumptions are that are going into the models, and then come to your own judgment. You know, do you think that the assumptions that have gone into the models of the various witnesses are reasonable or not? That's what's most important, not whether you used a particular type of production cost model or you used a regression analysis in combination with a production cost model. That's not so much the issue. The issue is, are you making reasonable assumptions and likely to get a good result?
Okay, thank you. My next question is, if you put your chairman hat back on just for a moment, would you seek to have some ability, given the fact that we don't know exactly what's going to happen with the market, would you seek to have some flexibility to protect ratepayers over this 20-year period? Is that something that you, as the former chairman, might seek to adopt?
Yes, if you don't mind, if I could just expand my viewpoint on that related to the issue. I think we're at an interesting time in the industry, because one thing that's happened in Massachusetts, and that's happening, I think, in a lot of states at this point, is making a specific responsibility of the Public Utility Commission to consider not only ratepayer impact, but also to think about how does what the commission is doing affect the energy policy and the climate policy of the state. So on a going forward basis, of course, it's your responsibility to focus on reliability and consumer impacts. Absolutely, always has been, always will be. But I think when you look at what needs to happen going forward in order for states to meet their climate mandates, getting to net zero sometime between 2040 and 2050, that it becomes a complicated analysis. You always want to protect consumers, but on the other hand, what resources need to be brought into service in order to make reasonable progress on the pathway to decarbonization? And so the answer to your question is yes, and I apologize for going on about this, but I do think it's important to have that energy and climate policy context in the back of your mind as you review offers to provide resources that don't emit greenhouse gases.
I appreciate that, and I think that we are charged with that, but we also are charged with a very specific, not to exceed 88 cents number, so that we are equally charged with making sure that doesn't happen. So
Absolutely.
Acknowledging that that's what our statute has in it. I think I heard you say that, flexibility to, over time, provide some protections to ratepayers is something that would be a reasonable goal if you were faced with this as a commissioner.
Of course. I mean, we have taken the whole purpose of restructuring was try to remove risk from ratepayers. I think what a lot of states are grappling with right now is that in order to meet the decarbonization mandates, ratepayers are taking back on some portion of that risk that was released with restructuring of the industry. And that's true in every state. But balancing that, of course, with your statute that sets a very specific threshold, the offers have to meet that threshold. But I think understanding exactly what the inputs and data and assumptions that go into the analysis that determine whether or not offers meet that threshold is the most important piece of the case before you now.
Okay, thank you very much. I appreciate your testimony. Thank you, Mr. Chairman.
You're welcome.
Thank you. Mr. Hibbert, just a question for you. You stated that this should not, at least for the commission's consideration, be a battle of the various modeling software. obviously you disagree with the testimonies of Mr. Chang, Mr. Repshar, and ICF. But is it your position that, notwithstanding the fact that the commission and its regulations do not require any particular analysis, and you have your own modeling platform here, would you say that all of the other platforms and analyses that have been provided to the commission are within the zone of reasonableness?
Yes.
Okay, thank you.
And that's why I apologize, Chairman. That's why I think, you know, the focus here really is on those inputs and those assumptions. It's not the modeling platform.
Thank you, Commissioner Richard.
Thank you, Mr. Chairman, and welcome, Mr. Chairman. Appreciate your testimony this morning. I'm interested, as Commissioner Herman discussed, we do have this requirement that we must consider ratepayer impact, and since we have the independent ICF, I'm just trying to look at that analysis, and also be open though to some of the other discussion about various analysis we might use. And I think it brought to our attention that we did use the Aurora production cost market model in our first decision. Is that correct?
Yeah.
Okay, so that has been something we've used in the past, recent past.
Actually, Commissioner, I apologize. I misspoke. My understanding is that what's happened in the past is that econometrics were used in the ratepayer impact analysis or in the market impact analysis. I don't recall that last time around Aurora was used as to establish the base pricing. That's as part of that.
Okay. Now, is Aurora similar to I guess other regression analysis? I mean,
well, Aurora is the piece that relates to establishing the base price forecast through a production cost model. So I would put Aurora in the category of ProMod, the IPM model, the various production cost models that are used. The piece that you approved last time around and that was put forth by Skipjack in this proceeding is using econometric analysis on top of using production cost model or some other way of getting to a base price forecast. So the difference here is the econometric piece, not the Aurora or production cost model piece.
Okay, well, I appreciate that. I'm just trying to understand what our basis for our decision was in the round one and round two, and understanding what the Bates White is bringing to the table that might be different from ICF, and just try to compare those two decisions. So with regard to the ICF, I mean, there are some, I guess, variables that have changed since the original ICF was done, the report was done. Now, one is the effective load carrying capacity. That changed. If we were to put the new number, the new PGM number into that the ICF analysis, would that make any changes as far as maybe changing the outcome of the ratepayer impact?
If anytime you change the effective load carrying capacity of a potential capacity resource, it's ultimately going to change, all else equal, the revenues that would be earned in the capacity market. So I know that all of the regions, PJM, New England, New York, are all dealing right now with how do we appropriately assign load carrying capability to specific kinds of resources. It's not clear to me exactly where that's going to land at this point, but two things happen when you change the electric load carrying capability. You affect the supply side and you affect the demand side, the demand curves that are used in the capacity market. And when we've done analysis on this in the past, we've found that capacity market prices change to some extent when you change the effective load carrying capability of resources. So you can't say that, for example, if a particular resource gets a lower ELCC, that it will necessarily have lower revenues coming from the capacity market because it changes on both sides of the supply and demand equation in the capacity market. So if you adopt a particular load carrying capability for the resources being proposed here in this case, I wouldn't come to the conclusion that the end result of the total revenues they would earn in the capacity market would necessarily change that much.
Okay, so there would not be increased revenues. It's my understanding that in fact PJM increased the effective load carrying capacity of offshore wind, and I was interpreting that as an improvement in overall revenues, and therefore would be very helpful to both projects in the analysis on the impact on ratepayers. Am I putting this all together correctly?
Yeah, you are. You're absolutely putting it together correctly, and that makes sense, all else equal. The part that's complicated is you just can't pin down exactly what the final capacity market price ends up being, because in complicated ways, the effective load carrying capability of all the resources on the system affect both sides of the equation. You hold all else equal. If all that's happening is you're increasing the load carrying capability of the resource, then its revenues in the capacity market will increase.
Okay. There's also, and Commissioner Herman brought this up yesterday, a difference in the analysis between the two projects on the capacity factors. Now, these seem to be the same exact wind turbine that are being considered for both projects. I mean, if those were both, if both an analysis for both projects use the same capacity factor, would that have some kind of an effect overall in how we look at the overall ratepayer impact, given that at least in one case it would improve the output of the project?
Yeah, absolutely. I think that when you the capacity factor will just directly affect the total revenues that the resource would earn in the energy market. Higher capacity factor, more megawatt hours sold, and more revenues from the energy market.
Okay, so again, improve the performance of the wind towers. That will have a beneficial effect as far as lowering the impact on ratepayers. Is that am I connecting that correctly?
Yeah, it would have two effects. It would increase the revenues earned by the offsetting energy market revenues earned by the resource itself. But also, if you're increasing the generation output by assuming a higher capacity factor, you're also having an increased impact on wholesale market prices, which benefits all ratepayers in the state.
Okay. And then I also wanted to, I mean, one of the assumptions in Mr. Kane's analysis is, and I think you also point to the fact with electrification, the assumption of electrification, we are going to increase the demand overall for electricity, and that should have, I guess, a suppressing effect on the overall cost, or yeah, the overall cost of electricity. Because of the increase in the production, the renewable production.
Increasing renewable production will overall have beneficial impacts. Again, all else held equal, but electrification, I think, is it's one of the reasons I encourage you to focus on this as an issue to try to think through is that electrification will dramatically increase the demand on the electric system. And so that could lead to prices staying the same or potentially even increasing. The important, and I would expect over time, all else equal, if you increase the electricity demand, you're actually increasing the prices for electricity in many hours. And the impact is not small. When we have looked at this, when I have looked at this in the New England context and for some municipal utilities, you only need to make assumptions of electrification in the building sector of half the homes going to electric heating and maybe half or 2/3 of the vehicles, the light duty vehicles in the state or in a region going to electric vehicles to massively increase electricity demand on the system. And so that's why I think if the states are actually going to meet their climate mandates that are in law and regulation, it's likely to require a huge amount of electrification over a relatively short period of time. And so I think that will really increase demand in the sector, and all else equal, that would tend to increase prices, not decrease prices. But the adding more and more renewables to meet that demand will have the opposite effect. It'll have the effect of driving down prices.
Okay, and that's what I was trying to understand, because it seemed like, in a sense, Mr. Kane was arguing both sides of it, that we're going to be, by proving these two projects, or by proving a project, we're going to increase renewables, and that's going to have a suppressing effect.
Yep.
But I was trying to understand why the fact that electrification is going to increase demand, that doesn't offset that effect.
It does offset it, but not necessarily 100%. It depends upon the magnitude, right? So really the impact of electrification will be to increase electricity demand in most, if not all, hours of the year, which all else equal will increase locational marginal prices across the state. And that's likely to be the result. What's happening at the same time is the more wind that gets brought in, the more solar that gets brought in will have that suppressing effect. So it's difficult to say, how does this tease out? But if we have much higher demand on the system, the actual price suppressing effect of a megawatt hour from a wind resource will be greater than if we don't have that increase in demand. So if you don't assume much load increase, the market impact of renewable resources, of these wind resources, will be smaller than if you have a lot of electrification built into the model, which will tend to start at a higher baseline price, so that the magnitude of the impact of the renewable resources will be larger in that scenario.
Okay. Thank you for that. No more questions. Thank you, Mr. Chairman.
Thank you.
Commissioner O'Donnell, did you have questions?
Mr. Chairman, Commissioner Richard asked some of my questions, so I'm satisfied. I don't need to redo them.
Thank you.
Thank you, Commissioner.
Do council have questions based on the commissioner's questioning of Mr. Hibbard?
We do not.
Thank you. Seeing none, Mr. Hibbard, you may step down. Thank you.
Thank you very much.
Mr. Coran, you may call your next witness.
It'll take me a second to swap out chairs or get Mr. Kane in here, but we'll be calling Mr. Kane next.
Thank you. And for planning purposes, we'll take a 15-minute break in about an hour. And once again, if you are planning to cross-examine Mr. Kane, your camera should be on at this point.
Mr. Chairman, we'll be calling Colin Kane to the stand.
Thank you, sir. If you could please turn on your camera and raise your right hand.
Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Your witness.
Mr. Kane, would you be kind enough to state your full name for the record?
Colin Kane.
And sir, what is your business address?
It's 2001 K Street Northwest, Washington, D.C.
Mr. Kane, who is your employer and what is your title?
My employer is Bates White Economic Consulting, and my title is partner.
Thank you. And who are you testifying on behalf today, sir?
Skipjack Offshore Energy.
Let me ask you, Mr. Kane, do you have before you two documents entitled the Public and Confidential Direct Testimony of Colin Kane, filed August 25th, 2021, consisting of 28 pages and one exhibit?
Yes.
And let me ask you, do you also have before you two documents entitled the Public and Confidential Errata of the Direct Testimony of Colin Kane, filed October 14th, 2021, consisting of 3 pages and 2 attachments?
Yes.
And what is the purpose of the errata, sir?
The errata addresses an input price assumption that was corrected in the in our model, and so it updates the numbers in my testimony to reflect that.
Thank you. Your Honor, we would like to have the public version of Mr. Kane's direct testimony and exhibits, errata and attachments, and models supporting this testimony referenced therein, which were pre-marked and provided to the commission as Skipjack Exhibit 10 to be marked as Skipjack Exhibit 10.
So marked.
And we'd also like the confidential version of Mr. Kane's direct testimony, exhibits, errata, et cetera, which were pre-marked as Exhibit 10C to again be marked as Skipjack Exhibit 10C.
So marked.
Mr. Kane, let me ask you, do you also have before you two documents entitled the public supplemental direct of Colin Kane and the confidential supplemental direct of Colin Kane, both dated September 24th, 2021, consisting of 29 pages of testimony and no exhibits?
Yes.
Your Honor, we'd like the public and confidential versions of Mr. Kane's supplemental direct to be that were provided to the parties in the commission as Skipjack Exhibits 11 and 11C to be marked as Skipjack Exhibits 11 and 11C.
So marked.
And finally, Mr. Kane, do you have before you two documents entitled respectively the public and confidential rebuttal testimony of Colin Kane, dated October 18th, 2021, consisting of 33 pages and two exhibits?
Yes, I do.
And Your Honor, we would like these documents to be marked as Skipjack Exhibits 12 and 12C.
So marked.
Thank you. Mr. Kane, were these testimonies that are before you, were they prepared by you or under your supervision?
Yes, they were.
And today, do you have any additions, corrections, or modifications to those testimonies?
No.
So if I were to ask you the same questions today that were contained in your direct, your supplemental direct, and rebuttal testimonies, would your answers be the same?
Yes.
And are your testimonies true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, at this time, we would respectfully ask the commission to move applicants' exhibits 10, 10C, 11, 11C, 12, and 12C into evidence.
The aforementioned 6 exhibits are moved into evidence.
Thank you. Your Honor, we have just one brief line of rejoinder, which will take a moment if we may.
You may.
Thank you. Mr. Kane, have you had an opportunity to review Mr. Rupture's rebuttal testimony that was filed in these proceedings on October 18th, 2021?
Yes, I have.
And do you have that with you?
Yes.
Can I ask you to turn to page 13 of Mr. Rupture's rebuttal testimony?
Yes, I'm there.
Do you see where he states that the analysis of Skipjack suffers from a lack of support for certain assumptions made? And then he goes on, e.g. aggressive load growth assumptions?
Yes.
And what is your response to Mr. Rupture's rebuttal testimony on aggressive load growth assumptions?
Well, as you know, first I would say that that they're not especially aggressive, and I've addressed in my testimony the scenario that I'm looking at and the consistency of that scenario with the statutory directives and the appropriateness of those assumptions with respect to the analysis I've performed. I'd also like to point out, and I think this is important with respect to concerns expressed by commissioners, is that it's not a substantial driver of the results of my analysis. And just for example, if you set the load growth assumptions to 0 rather than the 1.5% a year that I assumed, both skipjack projects would still pass the residential and the non-residential impact tests. So I've selected a scenario that I think is representative of the future that that Maryland and the region faces, but it is not a substantial driver of the results of my analysis.
Thank you, Your Honor. With that, the witness is now available for live for cross-examination.
And I see 3 parties will examine the witness. We'll start with U.S. Wind, then OPC, followed by staff. Those are the 3 parties that seek to cross-examine. Counsel for U.S. Wind.
Thank you, Your Honor. Thank you, Mr. Curran. Thank you, Mr. Kane, and everyone else. I appreciate your time as well. I actually thought maybe I would start briefly with load growth assumption only and go off script for a second here, just because it just came up and I wanted to see what you had to say. Load growth assumption, your assumption is that for every year during the project period, it will grow. The load will grow by 1.5% each year, correct?
To be clear, that's an assumption about Maryland retail sales growth.
Okay, when you say load growth, what were you referring to?
Well, there is a distinction in the pieces of the model. There's a load growth assumption that is captured within the production cost simulation modeling that is sort of produces the foundation energy prices that are used to value energy going forward. And there's a retail sales growth assumption. And the load growth assumption for all of PJM and for that matter, the Eastern Interconnect that is embodied in the PA consulting production cost simulation that produces the energy prices that I adopt in my model, it does not reflect a 1.5% growth in load every year. It's substantially lower than that.
Okay, I understand the distinction you're making. I think it'll be too hard to go through right now. We are going to come back to that though. Thank you.
Okay.
Let me start where I initially intended to start, which is you have provided a number of opinions in this case with respect to various aspects of the Maryland legislative mandate and Code of Maryland regulations and compliance therewith. Is that correct?
Yes.
And can you just tell us briefly the categories that you provided opinion on?
Well, I would be happy to respond to specific elements if you want to point me to them in my testimony.
Do you provide an opinion on in-state benefits?
I provide an estimate of in-state benefits, and I point to the requirement of in-state benefits as being an element of the offshore wind rules.
Okay, understood. And you provide an environmental assessment of carbon offsets, correct?
Of reduced emissions, yes.
And you provide a ratepayer analysis as well, correct?
That's correct.
Okay. For the purpose of today's questioning, and do you know of any other opinions that you provide with respect to Skipjack's application and compliance with the statute?
I would have to review line by line to see if there's anything omitted, but I think that you've captured the essence of it.
The big categories?
Yes.
Okay, well, for the purpose of today's conversation, I'd really like to focus the attention on the ratepayer analysis. I think the commissioners have the most question on that, as do I. Is that okay with you?
Sure.
Where does the ratepayer analysis come from? Why are we doing it? Is that a legislative mandate?
It is mandated in legislation, yes.
Would that be 7-704.1 of the Code of Maryland of the Maryland Code?
Subject to check, yes.
Public Utilities article, excuse me. And it also appears in the Code of Maryland Regulations 20.61.6.03, correct?
I don't know that for sure, but I'll accept that.
But you'll accept as well that Maryland has created statutory caps in this OREC process to protect ratepayers on some level, correct?
Yes, to place limits on their exposure to cost, yes.
And to place limits on bids to prevent ratepayers from exposure to cost or risk, correct?
I'm sorry, I didn't hear that. You broke up in that sentence. Could you repeat that?
I said, in effect, the legislator is putting some limits on the amount people can bid because they're concerned that they want to protect ratepayers from certain costs and risks, correct?
Well, I guess it would be, holding all else equal, that might be true. The question is, how are you doing the evaluation? The bid level is not determined in the statute. The question of how you evaluate the impact is not established in the statute, except in very broad terms. And so it is a rate impact limit for residential and non-residential that's specified.
But you agree with me on the general principle, I think, that the legislator cares about the impact on ratepayers, and that's really important, and that's why there's this analysis, correct?
Absolutely.
There's two different kinds of ratepayer caps under the statute and under COMAR, isn't that right?
Yes.
And what are those?
There's a residential rate impact limit and there's a non-residential rate impact limit.
What is the residential rate impact limit?
The residential rate impact limit is specified as an average impact over the OREC period in terms of, I'm not sure exactly what the units are in, I think it's 88 cents per month as specified in the statute. And given the other assumptions that go along with that of 12,000 kilowatt hours a year consumption on average, that is equivalent to 88 cents per megawatt hour.
88 cents per megawatt hour.
Yeah.
And what is the non-residential rate impact limit prescribed by the legislature?
The non-residential impact limit is specified somewhat differently. It's specified as a percentage, a maximum percentage of annual impact on non-residential rates. So rather than looking at the full OREC period and doing an average, which is how the residential impact test is specified, the non-residential impact is looking at a percentage impact on non-residential rates and specifying that can't exceed 9.9% in any year. At least that's my reading of the statute. There's some ambiguity there.
And in any given year. So with the non-residential, there can never be a year in which you fail the non-residential test under the new statutory scheme, correct? You can't levelize it as you can with the residential test.
Yes, that's my interpretation. I think that for instance, in the ICF report, there was some question about what exactly the interpretation of that limit was, but that is my interpretation, that each year has to pass that test for the non-residential.
And that's different than it was before in the first OREC proceeding, isn't that right?
That's right. I believe that's correct.
And what was the case in the first? What was the situation in the first OREC proceeding with respect to the calculation of the non-residential price?
I am not 100% sure of exactly what the methodology was. My rough understanding is that it was more akin to the residential, that it was an average impact.
If I said I agreed with you about that, it was more akin to the residential and it allowed for a levelized impact. Would you agree with me that the legislator has made the residential impact test, excuse me, let me restate that. Would you agree with me that the legislator has made ratepayer impact tests more stringent since the last OREC, between that one and this one?
I actually couldn't conclude that. The question is, because it's specified in a percentage impact term as opposed to an absolute dollar term, it's not clear to me that that's necessarily true.
Would you agree with me, though, that the general impact of not being able to levelize the non-residential price creates additional downward pressure on the OREC price that you can bid? Or that an applicant can bid, I should say.
I just can't say that a priori that's follows from the 9.9% annual impact relative to what applied previously. I don't know that that's true.
The 0.9%.
The 0.9%, yeah.
So the fact that you have to meet the 0.9% in every given year, as opposed to being able to take it and have, as opposed to being able to have years where you can miss it, that doesn't create, you're not sure if that creates downward pressure on OREC price.
No, it would depend on how that 0.9% is translated into. It could be the 0.9% could result in a much higher headroom. You might still have to meet it every year, but it might create higher headroom. I just don't know the answer to that question.
I'll accept that. At this point, I'd like to refer you to, I'd like to walk through with you your, some specifics about your opinion and your ratepayer analysis. Is that okay?
Sure.
I'd like to begin by referring you to, and I believe this is your supplemental direct testimony. And Mr. Kern may be able to help me here. I believe that was entered as Exhibit 11 or 11C. I think that what I am looking at is 11C,
Okay.
I believe. And Mr. Kern, I am going to ask him a question out of a table in my 11C, which has been previously marked as attorney's eyes only. May I ask that question in public session?
Well, what table are you?
It's on page 20, page 29, and it is the summary of his ratepayer analysis.
Is it table 3?
It's table 3.
Mr. Previs, I'm looking at the supplemental direct and I don't have a table on page 20.
29.
29,
Oh,
Your Honor.
29. Thank you.
So, Mr. Coran, what say you with respect to discussing this publicly?
But he can discuss it in public session.
Okay, thank you. So we're looking at page 29, table 3 on the supplemental direct.
Thank you. And I'll just give everyone a moment to get there if we'll make sure commissioners and everyone have time. Okay, and Mr. Kane, are you there?
I'm here now. Yes.
Okay, great.
Took a moment.
It's good that we're on the same page, literally. First column says, and I'm going to, just to simplify things today, unless I tell you otherwise, can we just focus on skipjack 2.1 because I don't want to get confused between bids. Is that okay?
That makes sense.
And that's the roughly 800 megawatt bid. Is that right?
That's correct.
So if I go to the first column, impact limit, do you see that there?
Yes.
And it says residential $2,008 per megawatt hour, 88 cents. Is that right?
$2018 per megawatt hour, 88 cents. Yes.
And thank you for that correction. I think I misspoke. Did I say 2008?
Yes.
Okay, my apologies. And that's the statutory cap, correct?
Yes, it is.
And you have the same reflection of the statutory cap in the right-hand column with respect to the non-residential impact, correct?
That's right.
And if we scroll down, well, this is how much I've been using computers over COVID. I'm scrolling and I'm actually using paper. That tells you something. Skipjack 2.1, it says the residential impact is 8 cents, correct?
Yes.
And so it's your opinion that the impact is 8 cents, and so well beneath the impact limit of 88 cents. Is that correct?
That's right.
And on the non-residential, it says that your opinion is 0.62%, correct?
Yes.
And so it is your opinion that Skipjack's price and ratepayer impact is well below the impact limit of 0.9%. Is that correct?
Yes.
And if I were to add a third column to this table, and I wrote the word ICF in the left-hand table, and I went to the first column and it said residential $2,018 per megawatt hour, and it was reflecting ICF's opinion of the Skipjack project's ratepayer impact. Would you agree with me that that cell would be populated with the number $1.99?
Based on my recollection, I think that's correct. Yes.
So you're at 8 cents and ICF's at $1.99 with respect to the residential ratepayer impact of the skipjack 2.1 bid, correct?
Yes, that's correct. The ICF places a very low value on offshore wind.
And if we continue to the next column over, which would be the non-residential impact, and I did the exact same process, and I inserted the ICF as an additional, I think I said column before, an additional row beneath skipjack 2.1. That number would be 2.9%, correct?
Again, subject to my recollection, and I think that that's in the ICF report, yes.
That sounds about right. So that, and when I said that number, I just want to be very clear that I mean that ICF's opinion is that skipjack 2.1 as bid has a 2.9% non-residential max annual percent impact, correct?
Again, subject to my recollection, I believe that's correct, yes.
And so it's not a small difference of opinion between you and ICF as to whether skipjack's bid 2.1 passes the ratepayer impact test, correct?
No, that's correct. I think ICF has produced about as low a possible estimate of offshore wind value as it's conceivable to do.
I'd like to now refer you to your worksheet, which were just entered into evidence and I believe are reflected as skipjack pre-marked exhibit skipjack 10C.
Yeah, that might take a moment as well.
Yes, and it's going to take a moment for everyone. And I would just ask everyone, there are a host of tabs on this spreadsheet. The only tab I, at this moment, intend to ask questions about is the one that says $ per MWH at the bottom, dollar per megawatt hour.
Mr. Priebus, what page are you on? 10C is Mr. Kane's direct testimony.
So in the pre-marked exhibits, skipjack, there's something called skipjack exhibit 10C, OPC 2-19 replacement attachment 1, which is, as I understand, the model that supports the testimony of 10C that was also part of what was just moved into evidence in relationship to the direct testimony. This is his workbook.
Okay, we're getting it now, Your Honor.
I'm not sure where this is, so you're gonna have to give us a little while here.
Yeah.
Yeah. Yeah. Okay, great. All right, I have it on my screen. Not sure what others are going to do in terms of locating it.
Commissioners found this document?
I haven't.
Okay, so we're
Give me a
looking
hint.
at direct testimony, the confidential direct testimony of the witness. So this is 10C, correct, Mr. Priebus?
This is, so Mr. Curran moved in the models and the supporting documents for the direct testimony. And in skipjack pre-mark confidential exhibits 10.26.2021 update, which we received recently, it has an exhibit marked 10C, and it says skipjack exhibit 10C, and then it says OPC 219 replacement attachment 1 parentheses confidential .xls. And this is his workbook.
That's right. These are the work papers that are attached to his testimony. So that was the confusion. I thought you were referring to a page number of his direct testimony. This is the attachments to the testimony.
I apologize if I caused any confusion. That's exactly right.
No, I understand that now. We do have the 10C testimony in front of us. I'm having a little trouble finding the attachments in our. Here, I just found it.
Just for the commission and Mr. Previs, the work papers that he's referring to are confidential. So I don't know if this is, he wants to reserve discussion of this until later, or he wants to start his confidential session now.
Mr. Previs?
I want to make sure, it may be appropriate to move to confidential session, and I really feel like I would like the commission to make sure they have time to find everything as well, so that we're all working from the same page. And so maybe we take a moment. I would be happy to email it or otherwise provide it to make things easy.
That might be best for the commissioners if you could email them to us right now, so we all have a copy.
If there's I don't believe the commission has had sharing screen available either, but I don't know if that's something you would entertain.
If there's no objection from Skipjack Council, if you can screen share, we could provide you with that ability. That might make it easier.
We have no objection to that as long as we're in confidential session. So for this material.
Mr. Chairman, can I ask that if he does email it, that he email it to the parties as well, please? I'm also having trouble finding it.
Okay, we're all having trouble finding it. Well, Mr. Spivak, I think he's going to post it when we move into confidential session, so you'll be able to see it on the screen, and we'll get our files back in order. All right, so Mr. Previs, at this time, you're prepared to move into confidential session?
I am, Mr. Chairman. I would respectfully request, because I just want to make sure that we have the technology working properly for the share screen, because I had anticipated we would be using this. Everyone would be pulling it up the way we did it yesterday. It may be appropriate to have a 5 or 10 minute recess if it's okay with you, to both move to the confidential session and to ensure that technologically we're sound with the screen sharing of this document.
That is fine. We'll do that. I understand the parties have requested expedited treatment from the court reporter, and she does need time to move her files over. So we'll take a break until 11:25. So 17 minutes from now, 11:25. We could cut the feed now, and for those watching on the YouTube stream, you'll receive a notification if you're subscribed to the channel when we go back live later this morning. So we're in recess until 11:25.
Thank you.